Good day, and welcome to the U.S. Commission on Civil Rights public briefing. Today's event is being recorded. At this time, I would like to turn the conference over to Chair Rochelle Garza. Please go ahead.
This briefing of the United States Commission on Civil Rights comes to order at 10:01 a.m. Eastern Time on March 8th, 2024, and takes place at the Commission headquarters at 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C. 20425. Good morning, everyone. I'm the chair of the Commission, Rochelle Garza, and joining me today in person for this briefing are Commissioner Adams, Commissioner Gilchrist, Commissioner Harriet, and Commissioner Jones. On the phone, if you can confirm you are present after I say your name, I believe we have Vice Chair Nurse, Commissioner Kirsanow,
Here.
Commissioner McIntyre.
All right.
Great. Will the court reporter confirm for the record that you are present? Mr. Staff Director, will you confirm that you are present?
I am present.
Wonderful. I welcome everyone to our briefing titled The Civil Rights Implications of the Federal Use of Facial Recognition Technology. Our focus today centers on the civil rights implications of facial recognition technology, or FRT. We're going to be using that acronym. It's a subject that demands our urgent attention as we navigate the complexities of of technology's role in our society. We aim to unpack the nuances of FRT's development, its deployment by key federal agencies, the civil rights concerns it brings to the forefront, and most importantly, the crucial safeguards needed to mitigate potential violations of these rights. And while many government entities use facial recognition technology, the focus of today's briefing are on three cabinet agencies: the U.S. Department of Justice, or the DOJ, the U.S. Department of Homeland Security, DHS, and the U.S. Department of Housing and Urban Development, or HUD. FRT is advancing at an unprecedented pace, finding its way into policing, public housing, airports, and other public spheres. And while the technology offers potential benefits, it also possesses serious threats to our fundamental rights. It's crucial that we examine these issues with the lens of civil rights at the forefront. One of the most pressing concerns of FRT is its disproportionate impact on marginalized groups. People of color, LGBTQ individuals, women, people with disabilities, religious minorities are often unfairly targeted by this technology. Take, for instance, the cases of Robert Williams, Michael Oliver, and Najir Parks, all Black men wrongfully identified and arrested due to flawed FRT. These are not isolated incidents, but examples of a systemic issue. And beyond the issue of bias, FRT poses a stark threat to our constitutional freedoms. It has the potential to infringe on our rights to privacy, free speech, and association. Imagine a society where your every public move, habit, and association is tracked. It's a scenario that's eerily mirrors dystopian fiction, yet it's becoming a reality with the advancement of this technology. And it is for this reason and a bevy of others that the Commission has undertaken the responsibility to analyze how FRT is developed, how it is being utilized by federal agencies, and find the necessary safeguards the federal government is implementing to mitigate these potential civil rights violations. And as we delve into these issues today, we're going to hear from a wide array of stakeholders and subject matter experts that include government officials, law enforcement, academics, researchers, industry, and legal experts. We unfortunately will not have representatives from the Department of Justice or Housing and Urban Development testify in person today. However, we anticipate their submission of written testimony and look forward to reviewing it. Today's public briefing marks this Commission's first step towards investigating the breadth of the challenges that FRT may pose and moving towards solutions that respect and safeguard all of our civil liberties. We're going to hear from four panels that cover the following. The first panel will cover understanding facial recognition technology and civil rights implications. Panel 2 will cover federal government utilization and safeguard implementation of facial recognition technology. Panel 3 will cover guidance for meaningful federal oversight. Panel 4 will cover actions for strengthening responsible federal facial recognition technology practices and policies. And following the conclusion of the hearing, the Commission will accept written public comments until April the 8th of 2024. So I'd like to thank all of the individuals who joined us today to focus on this critical topic. Your testimony will help us fulfill our mission to be the nation's eyes and ears on civil rights. And finally, I'd like to thank the Commission staff, including our special assistants, the Office of Civil Rights Evaluation, General Counsel, our technology team that makes all of this possible, and everyone who has supported this briefing substantively and logistically. I'm now going to turn the floor over to Commissioner Mondaire Jones, the lead commissioner on this report, who has spearheaded this topic.
Thank you so much, Madam Chair, for your leadership and for your vision. I want to thank my fellow commissioners for their support of today's hearing. On the first topic that I propose as a new member of this body, I am especially proud of having worked in a bipartisan fashion, which is rare these days, with my colleague, Commissioner Gilchrist, to get my proposal across the finish line. It is as much a testament to our ability to actually function, even as we are oftentimes evenly divided, as it is a testament to the universal concern that Americans have about the issue of facial recognition technology in particular, and of course, artificial intelligence more generally. I want to thank the Commission staff, especially my special assistant, Irena Vidulovic, for their hard work in the months and in the days leading up to today's briefing. Today's hearing and our subsequent report, as you have heard, will analyze how facial recognition technology is developed, how it is being used by the federal government, emerging civil rights concerns, and safeguards that the federal government can and should implement to address what we are clearly seeing as glaring civil rights issues. In particular, this project will review the use of facial recognition technology by the Departments of Justice, Homeland Security, and Housing and Urban Development. I want to thank DHS, in particular, for participating in today's briefing, both through its written testimony and through the numerous representatives that it has sent to testify today in person. I appreciate that DHS takes its statutory obligations and the work of this commission seriously. By contrast, I find it not just disappointing, but offensive that DOJ and HUD declined our invitation to appear in person today, and thus far have not even submitted written testimony. I have not seen anything like this from this administration. And had the Commission been given adequate notice of the failure of these departments to cooperate, I would have urged this Commission to exercise its statutory authority to issue subpoenas, which is something that we have rarely had to do in the course of this Commission's existence. As someone who approached this briefing with an open mind and without any predispositions, I regret that I've had to take a dim view of why these two departments have chosen not to cooperate with the Commission's legitimate inquiry into their use of facial recognition technology. It suggests to me that DOJ and HUD are embarrassed by their failures and are seeking to avoid public accountability. I also believe that their approach is a strategic error, because now Congress is going to pay even closer attention. So will the press, which is well represented here today, and most importantly, so will the American people. Along with representatives from DHS, I'm delighted that our briefing will have in-person testimony from subject matter experts, academics, researchers, software developers, civil rights and civil liberties advocates, the White House, and of course, legal experts. The Commission has also received written testimony from my former colleagues, Congresswoman Yvette Clarke and Congressman Ted Lieu, who lead important legislation in the House that deals with FRT broadly and its use by HUD specifically. Over the past few years, facial recognition technology has come under the scrutiny of civil rights advocates, legislative bodies, and the public as the use of this technology continues to grow. The use of FRT has become increasingly common across the federal government. In fact, a report by the Government Accountability Office, or GAO, showed that 18 of 24 surveyed federal agencies use FRT for one or more purposes. Another study of 42 agencies that employ law enforcement officers found that 14 of those agencies use FRT. Of those, 13, quote, did not track employee use of non-federal, for example, state and commercial FRT systems. GAO found that employees were not aware that they were using non-federal FRT systems and yet had conducted more than 1,000 facial recognition searches. Since there is widespread use of FRT in the federal government, the Commission has embarked on this important task to ensure that the federal government is protecting civil rights by making sure processes and protections exist, transparency is applied, and accountability is enforced. So I look forward to listening and learning today from experts who have for years been on the front lines of using, studying, and safeguarding against this technology. Thank you so much again.
Chair Garza.
Yes,
Might be
Commissioner.
recognized for just a brief comment.
Sure, that's fine.
I want to share Commissioner Jones's concern and support his concern about the absence of DOJ at this hearing. And I would also support any effort you would like to engineer or steer toward obtaining information from them. I would be wholeheartedly in support of that, even if it extends to exercising subpoena power. But I want to see your problem and raise you one. The Office of Legal Counsel at DOJ, OLC, and the Civil Rights Division, CRT, are going to be the primary drivers of any federal policy related to facial recognition technology. DHS has their own civil rights office, but it's effectively subservient to whatever OLC or CRT says about this policy. So not having them here takes away the central organizing component of the federal government to answer these questions. So I would support you and your concern and whatever steps you think are appropriate going forward.
Thank you, Commissioner Adams. And thank you, Commissioner Jones, for your statement. I'm going to now turn us to our briefing with a few housekeeping items. During the course of the testimony and the question and answer period, I caution all speakers, including commissioners, to refrain from speaking over each other for ease of transcription and to allow for sign language translation. I'd ask that we allow any individuals who might need to view the sign language translation to sit in the seats with a clear view. For any member of the public who would like to submit materials for our review, as I mentioned, we are going to be accepting materials through April the 8th of 2024. You can submit your materials by mail to the U.S. Commission on Civil Rights, Office of Civil Rights Evaluation at 1331 Pennsylvania Avenue, Northwest, Suite 1150, Washington, D.C. 20425, or by email. And the email address is frt@usccr.gov. During the briefing, each panelist will have 7 minutes to speak. After each panel presentation, commissioners will have the opportunity to ask questions within the allotted period of time, and I'll recognize any commissioner who wishes to speak. I will strictly enforce the time allotments given to each panelist to present his or her statement, and unless we did not receive your testimony until today, you may assume that we've read it. So you can summarize it, and we'll appreciate that so that you can make the best use of your time, of your 7 minutes. I ask my fellow commissioners to be cognizant of the interest of each commissioner to ask questions, so please be brief in asking your questions so that we can move quickly and efficiently through today's schedule. I will step in to move things along if needed, although I don't anticipate that. Panelists, please notice the system of warning lights that are in front of you. When the light turns from green to yellow, that means 2 minutes remain. When the light turns red, panelists should conclude your statements so you don't risk me cutting you off. My fellow commissioners and I will do our part to keep our questions and comments concise. And now we're going to turn to our first panel, Understanding Facial Recognition Technology and the Civil Rights Implications. And I'm going to go ahead and introduce our speakers. Thank you all for being here. And the order in which you'll be speaking is Bertram Lee, and I apologize if I mispronounce your name, technology policy expert, Greta Goodwin, PhD, Director, Homeland Security and Justice, U.S. Government Accountability Office, Han Ton That, Juan, I'm so sorry. Juan Tontat, founder and CEO of Clearview AI. Armando Aguilar, Assistant Chief, City of Miami Police Department. Michelle Ewert, Professor and Director of Law Clinic at Washburn University School of Law. And Katie Kinsey, Chief of Staff, Policing Project, NYU School of Law. And I'm going to ask each of you all to raise your hands so that we can swear you in. Will you swear and confirm that the information that you are about to provide us is true and accurate to the best of your knowledge and belief? Okay, affirmative from all. Mr. Lee, could you please begin?
Thank you, Chair Garza, Vice Chair Nurse, distinguished members of the Commission. My name is Bertram Lee, and I'm here on my personal capacity. The views that I expressed in today's hearing do not represent those of the National Telecommunications and Information Administration or of the Department of Commerce. Thank you for the opportunity to testify about the use of facial recognition technology by federal agencies. The last time I testified on this topic, almost 3 years ago, in front of House Judiciary Subcommittee on Crime, Terrorism, and Homeland Security, the AI revolution was just beginning. Few could have foreseen the broad adoption and impact that artificial intelligence would have on government and our society at large. While the AI landscape has changed, unfortunately, the many issues concerning facial recognition have not. I want to leave the Commission with 3 main points that are still unfortunately germane to the conversation around the federal use of facial recognition technology today. 1, facial recognition technologies are inherently biased. 2, improving accuracy will not mitigate the disparate impact of facial recognition technologies. And 3, facial recognition technologies only expand the current police state in frightening ways. Facial recognition technologies are inherently biased, and facial recognition technologies still disproportionately misidentify and misclassify people of color, trans people, women, and other marginalized groups, posing threats to communities' health, safety, and well-being. The reasons for these biases vary. In some cases, the cause of the bias is the database an image is being shared against. In others, it is due to historical bias that is built into these systems through training data. While the technology has improved due to technical advancements in the use of neural networks, the reality is that broad discrepancies remain between the different demographic groups based on age and race. For example, Clearview AI's facial recognition system was shown by the National Institute of Standards and Technology in a December study to be more than 400 times more likely to misidentify black women over 65 than young white men ages 20 to 35. While demographic testing is still ongoing through the NIST process, foundational discrepancies in the accuracy of facial recognition technology are still very much relevant today. There has been a long struggle for darker-skinned people to have their images accurately captured on camera. This fundamental flaw is now baked into databases and AI systems that are continuing to entrench discriminatory outcomes. There are now at least 7 people that we know of that have been misidentified by facial recognition technologies. These interactions with law enforcement can have life-altering impacts on the lives of those people. Improving accuracy will not mitigate the disparate impact of facial recognition. Improvement of the accuracy of facial recognition technology will not address the fundamental issue that facial recognition technology expands the scope and power of law enforcement and federal agencies. As the recent letter from 18 U.S. senators highlighted, there are not only legal implications of government use of these technologies, but also First Amendment, civil rights, and civil liberties implications as well. From the use of facial recognition technology to track Black Lives Matter protesters, to my previous back and forth with House Judiciary Chairman Jim Jordan, there are bipartisan concerns about the use of facial recognition technology by the government. Facial recognition technologies only expand the current police state. Facial recognition technologies have expanded the current police state and also the commercial surveillance state. Sadly, when I testified previously, the lack of oversight on facial recognition was staggering. 3 years later, the situation is even more dire than we could have imagined. In 2016, a Georgetown group that included current FTC Commissioner Alvaro Bedoya highlighted that more than 119 million million U.S. adults were in some sort of facial recognition database. That number grew in 2019, and now a majority of departments of motor vehicles in the U.S. use some form of facial recognition technology. These systems are connected to broader federal and local law enforcement databases with very little training. 2023 GAO study on federal law enforcement agencies' use of facial recognition technology highlighted the fact that only 2 of the 7 law enforcement agencies requiring trainings on the technology as of April 2023. Due to the number of searches and different facial recognition systems used, the broad access to these technologies and full accountability is almost impossible. In conclusion, evidence that facial recognition technology impedes civil and human rights has never been clear. Facial recognition technology and the biases that these systems contain only serve to continue this history of discrimination and disparate treatment of people of color. In the past 3 years, the continued expansion of surveillance technologies like facial recognition have not made communities of color safer. Instead, it has done the opposite. Use of facial recognition by federal agencies only further exposes people of color to the systemic racism of the criminal legal system, reinforcing racist narratives that black communities and other people of color are to be surveilled and over-policed at every turn. I urge the Commission to further investigate the use of facial recognition technology by the federal government, and to do what it can to shed light on the severe consequences that continued use of these technologies can have on the most vulnerable communities. I thank the Commission for the opportunity to address the serious concerns with this technology, and I look forward to answering your questions.
Thank you, Mr. Lee. We'll now hear from Dr. Goodwin.
Chair Garza, Vice Chair Nurse, and members of the Commission, thank you for the opportunity to discuss GAO's work on the use of facial recognition technology by federal law enforcement agencies. The capabilities and uses of this technology has expanded in recent years, and questions exist regarding the accuracy of the technology, the transparency in its usage, and the protection of privacy and civil rights. Facial recognition technology is a powerful tool that federal law enforcement agencies may use to help solve crimes. The technology allows law enforcement to quickly search through billions of photos to help identify an unknown suspect or victim in a crime scene photo or video. While the technology may support criminal investigations and help bring bad actors to justice, policymakers and federal agencies must consider the potential impact of its use on civil rights and civil liberties, because the potential for error and the potential to misidentify someone could lead to the arrest and prosecution of an innocent person. Civil liberties advocates have also noted that the use of facial recognition at certain events, like protests, could have a chilling effect on an individual's exercise of their First Amendment rights. GAO issued reports in 2021 and 2023 related to federal law enforcement's use of the technology. Today, I will focus on the information we learned from 7 law enforcement agencies within DOJ and DHS: the FBI, the DEA, the ATF, U.S. Marshals, Customs and Border Protection, Homeland Security Investigations, and the Secret Service. I will discuss the extent to which these law enforcement agencies owned and used the technology, develop policies to help protect civil rights and civil liberties, required staff to take training, and have taken steps to address selected privacy requirements. In 2021, we reported the results of a survey that we sent to federal agencies that employ law enforcement officers regarding their use of the technology. Federal agencies use this technology to support various law enforcement activities. For example, it was used by the ATF in an arson investigation. The individual was ultimately arrested, confessed to the arson, and was sentenced. We also learned that the technology was used to support criminal investigations related to the civil unrest following the killing of Mr. George Floyd in May of 2020. The agencies reported that these searches were on images of individuals suspected of violating the law. After the Capitol attack of January 6, 2021, the technology was used to generate leads and support criminal investigations. Last year, we analyzed the use of facial recognition services by commercial and nonprofit entities. The law enforcement agencies reported using 4 services in total from October 2019 to March 2022. All 7 law enforcement agencies initially used these services without requiring their staff to take training on topics such as how the technology works, what photos are appropriate to use, and how to interpret the results. About 60,000 searches were conducted before staff were required to take this type of training. We also reported that 3 agencies had policies specific to protecting civil rights and civil liberties when using the technology. While the remaining agencies did not have guidance or policies in place, officials told us that staff must abide by more general guidance that helps ensure these protections during investigations. I want to note that DHS has since issued a policy which include topics such as limiting the use of the technology, protecting privacy, civil rights, and civil liberties, and testing and evaluating the technology. DOJ officials told us they plan to issue a department-wide policy on facial recognition technology. Until that policy is finalized, they have issued interim guidance to help safeguard civil rights and civil liberties. We also reviewed DHS and DOJ's privacy requirements around the use of facial recognition services. We found mixed results. 3 of the agencies addressed some of the privacy requirements. The remaining 4 did not fully address any of the requirements. Program officials told us that they didn't fully address the requirements in part because they didn't initially recognize photos as personally identifiable information. They didn't realize staff had transmitted photos to facial recognition services, or they didn't fully coordinate with their privacy officials while acquiring these services. We made recommendations to DOJ and DHS related to privacy requirements. Both concurred with our recommendations. As of February 2024, they had not implemented our recs. As the capabilities and usage of facial recognition services and other biometric technologies increase, it is important that the appropriate privacy and civil liberties protections are in place. While these services may support investigations, our work has shown that additional federal actions are needed to help prevent potential abuses and to increase the public's confidence in law enforcement's use of this technology. Chair Garza, Vice Chair Norse, and members of the Commission, this concludes my remarks. I'm happy to answer any questions you have.
Thank you so much, Dr. Goodwin. We're going to now hear from Mr. Tonthat. Please proceed.
Dear Commissioner Garza and everyone else on the Commission, it's an honor and a pleasure to participate in our conversation today, which covers a very important topic of this technology's impact on civil rights. As a person of mixed race, it's especially important to me that this technology is deployed in a way that protects and enhances civil rights. I'm Juan Tonthat. I'm the founder and CEO of Clearview AI, a facial recognition search engine company. Our product is used by law enforcement and government agencies to solve crimes such as child exploitation, murder, money laundering, and financial fraud, as well to investigate threats to national security. It's used actually in an after-the-fact forensic manner, not in a real-time way, and it only searches public information collected from the internet. Our technology has been proven to be extremely effective tool for law enforcement. For example, our technology played an essential role in the investigation that followed the storming of the Capitol on January 6th by helping law enforcement agencies investigate unidentified persons pictured engaging in violence that day. I'd like to take this time to share 2 examples here of the positive use cases of facial recognition technology. The first example here that you can see on the poster on the right is a child exploitation case. In 2019, Homeland Security investigations were trying to identify an adult male who was molesting a 7-year-old girl and sharing the abuse video online. His face just happened to be in the video accidentally for just a second. They had no other clues or ways to identify the perpetrator, so they turned to Clearview AI. The top left photo, as you can see, is what they call the probe image, which is the image that law enforcement is trying to identify. That photo was uploaded to Clearview AI to search the public internet, and what came back was just one single image, which is the one on the right. You can see that the suspect is actually in the background of that photo. From the second photo, the investigators would learn 2 clues. Firstly, it was posted in Las Vegas, and secondly, the name of the employer where the suspect worked. From those 2 clues, they were able to talk to the employer, find a name, and get further evidence to get a search warrant. They found thousands of more images and videos of child exploitation on the suspect's device. Today, this man's doing 35 years in jail, and they were able to save a 7-year-old girl. This is a great example of how facial recognition is used in practice. First, it shows that investigative work is required to verify an identity after getting a result from facial recognition, and that human investigators are making the final judgment. Secondly, it shows a true impact of facial recognition and how it can combat the most heinous of crimes. The director of Homeland Security in that unit at the time said, without Clearview AI, there's no way they would have found that guy. The second example is actually regarding a public defender's usage of facial recognition technology to exonerate someone wrongfully accused of a crime they did not commit. So this is a story of Andrew Conlon. Andrew Conlon was facing 15 years in jail for vehicular manslaughter that he did not commit. He was a passenger in a horrific accident where the driver was killed and ejected from the vehicle quite a while ago. A good Samaritan came to the scene to rescue Andrew Conlon out of the passenger seat. The police then arrived and questioned the Good Samaritan, but forgot to get his contact information. But there was body cam footage of it. Later on, the prosecutor wrongfully accused Andrew of being the driver, and he was charged with vehicular manslaughter and facing 15 years for a crime he did not commit. His public defender was trying to find and identify who this Good Samaritan was from the body cam footage to try and have him testify. They tried everything: posters, appeals to the public, and so on. Eventually, they turned to Clearview AI. Clearview AI was able to find a lead of the Good Samaritan at a party in Florida on a webpage. With some other investigative work, they were able to get a name and a phone number. And once he heard the story, he was able to testify about what really happened that day, and the charges against Andrew Conlon were dropped. This was a long ordeal for Andrew, but it also shows the flip side of facial recognition, how it can be used by public defenders to also protect the innocent. While some may point to demographic differentials for facial recognition algorithms, what truly really matters is absolute accuracy. Clearview's algorithm has been tested by NIST's FRVT program, which measures accuracies using large data sets of millions of diverse photos of varying quality and poses. Our algorithm is shown to be 99% accurate across every demographic group and test category. In fact, the 1 to N FRVT test, which is the hardest one to do, the algorithm can pick the correct face out of a lineup of 12 million photos at an accuracy rate of 99.85%. That's much better than a human eye. Can you think of anyone who could find the correct photo out of 12 million at that level of accuracy consistently? I really do believe that accurate facial recognition with the appropriate controls, regulation, and training will decrease bias in policing. First, when law enforcement currently encounters a photo of a suspect from camera footage and is unable to identify them, they put out a BOLO, the Be on a Lookout For alert, to surrounding law enforcement agencies with a description of the suspect, which typically includes race, gender, and physical description. This causes law enforcement to look for suspects who match that description and question many people who are innocent, who are not the suspect. It can also involve things like unnecessary traffic stops and other police interactions with those who are innocent in the community. And so facial recognition, I truly believe, once accurate, can decrease unneeded police interactions and further trust with the community and the police. Secondly, police should have access to a facial recognition system that searches a broad population, not just photos of people who've been arrested before. Clearview AI's database is not just mugshots, it contains people from the public internet. This helps prevent bias against communities of colors and a narrow population of people who have arrest records. You can find more about this in my written statement, and thank you for your time.
Thank you so much for your testimony. Now we're going to proceed with Chief Aguilar.
Good morning, Chair Garza, Vice Chair, members of the Commission. I'm Armando Aguilar, Assistant Chief of Police with the Miami Police Department. I'm also currently serving on a 3-year term as a member of the Law Enforcement Subcommittee of the National Artificial Intelligence Advisory Committee, or NIAC-LE. I would, however, like to point out that I'm speaking today on behalf of the Miami Police Department and not on behalf of NIAC-LE. I'm proud to say that the Miami Police Department story is among the greatest turnaround stories in law enforcement. In 1980, Miami, with a murder rate comparable to that of Honduras, was America's murder capital. I became a Miami police officer in 2001 and a homicide detective in late 2004, a year where 69 people would be murdered in Miami, and another 6,400 would fall victim to violent crime. By this time, we had the audacity to high-five each other because at least we were no longer in the top 5 most violent cities in America. We were, though, perennially listed among America's top 25 most violent cities per capita. Fast forward to last year to 2023, Miami ended the year with 31 murders and 2,600 violent crimes. Still 31 and 2,600 too many, but a move in the right direction. Our murder clearance rate, the rate at which cases are solved last year, was 71% or 97% if we use the FBI's legacy reporting system, which credits solved cold cases. Our violent crime clearance rate was 58%. Now, for perspective, for most of my career, that murder clearance rate hovered around 45%, and our violent crime clearance rate below 38%. So what changed? Well, a great deal. I'll begin by stating that I've had the pleasure of leading the best generation of officers, detectives, and professional staff to ever serve the people of Miami. It all begins with community trust. Violent crime, especially unsolved violent crime, is among the greatest threats that serves to undermine that trust. For example, a shooting takes place. A community member calls our anonymous tip line and gives us the shooter's name. Absent any other evidence to support the tip, the investigation goes cold. People stop reporting gunfire, and the police, in turn, do not respond to gunfire that we do not know about. The perception among the community is that the police are, at best, unable to keep them safe, or at worst, unwilling to. Artificial intelligence helps bridge that gap by allowing law enforcement to solve and prevent crime and to protect our most vulnerable communities. The Miami Police Department has successfully leveraged artificial intelligence over the past few years to great effect. We use gunshot detection systems, public safety cameras, facial recognition technology, or FRT, video analytics, license plate readers, social media threat monitoring, and mobile data forensics. We use ballistic evidence to connect the dots between shootings and violent actors victimizing our communities. A recent BJA-funded study by Florida International University found that crimes where one such resource was used by our detectives had a 66% greater likelihood of being solved when compared against similar cases where no such resource was used. I'm happy to discuss any of the technologies that we employ, but I'll take this remaining time to discuss how we came to develop our policy governing the use of FRT in criminal investigations. For us, it started in 2020 when the New York Times ran an article that was critical of law enforcement use of FRT and of one company in particular. The author of the article, Kashmir Hill, posed several questions that resonated with me as I do spend my time out of uniform as a private citizen. Without proper safeguards, Ms. Hill asked, what would stop police from using FRT to identify peaceful protest organizers or stalking an attractive stranger at a cafe? And what about the public, whose biometric data, i.e. our faces, would be used by police? What sort of public input should be sought when deploying such technologies? My team and I set out to establish an FRT policy that would address these and other concerns. We were not the first law enforcement agency to use facial recognition or develop FR policy, but we were the first to be this transparent about it. We did not seek to impose our policy on the public. We asked them to help us write it. We started out by meeting with local privacy advocates, and they absolutely hated it. But we wanted to know why they hated it, so they were very happy to tell us. We found many of their critiques to be thoughtful and reasonable, so we heard their objections, took it upon ourselves to treat them as recommendations, and we incorporated several of them into our policy. We highlighted successful arrests aided by FRT through local media coverage. That March, we held 2 virtual town hall-style meetings. In-person meetings were not an option because due to the pandemic. We conducted 1 session in English, 1 session in Spanish. Each session, which included public questions and comments, had about 1,300 live views and 3,600 total views. The policy that resulted from our efforts created a narrow framework within which we would come to use FRT. Most importantly, our policy emphasizes that face recognition matches do not constitute probable cause to arrest. Matches are treated as anonymous tips, which must be corroborated by physical, testimony, or circumstantial evidence. We laid out 5 allowable uses: criminal investigations, internal affairs investigations, identifying cognitively impaired persons, deceased persons, and lawfully detained persons. We use it retrospectively. That is, we do not use it on a live or real-time basis to identify people going about their business in public spaces, or use it to identify people who are carrying out constitutionally protected activities such as free speech or religion. We established policy limiting who has access to our platforms, and we disclose our use of facial recognition to defense counsel in criminal cases. We do not substantively manipulate or alter probe photographs use composite sketches as probe photographs, or use any other technique that has not been scientifically validated. These efforts, along with many others, have resulted in a Miami that is safer today than in any other time in our history. I thank you for inviting me to testify before the Commission today, and I'm happy to answer any questions that you may have. Thank you.
Thank you, Chief Aguilar. We're going to now hear from Professor Ewert. Please proceed.
Good morning, and thank you to the commissioners for considering this important issue and for inviting me to speak with you today. I'm going to talk to you about how FRT is currently being used in affordable housing in general and subsidized housing, like public housing in particular, and the particular ways that it harms tenants. So I'll talk first about current uses and then about the problems that stem from those uses. So how is FRT being used today? First, for building access. More apartment complexes are using facial scans instead of keys or fobs to unlock doors into apartment buildings and within apartment buildings. And the rationale is that a tenant could lose their key or lose their fob, and that FRT is safer, but I'll talk to you about some of the problems that tenants in these buildings are having. The second use is tenant surveillance. We're seeing cameras outside and inside buildings, surveilling tenants, monitoring them, live streaming those feeds to police departments, and then or else sharing those recordings with law enforcement after the fact. So essentially warrantless searches, warrantless surveillance. And the rationale here is that this is supposed to deter crime and help police identify perpetrators. The 2023 Washington Post article that I included with my supplemental materials talks about the increased use of surveillance cameras in public housing. For example, the number of cameras per tenant in the Rolette, North Dakota public housing program rivals that of the number of cameras per inmate at Rikers Island. There are increasing concerns that use of this technology is not just for building access and tenant surveillance, that those are sort of pretextual in some situations, and that rather landlords are using these to evict tenants, to get rid of low-income residents, and then convert subsidized or affordable units to market rate units. And the Law Journal article that I submitted with my supplemental materials actually includes examples of how tech companies are advertising this as a way to get rid of affordable housing. So why is this use of FRT problematic for subsidized tenants? First, the technology is flawed. You heard Bertram Lee testify about inaccuracies based on race and gender and age, so I'm not going to belabor that point. But I will say that these problems or these inaccuracies are especially problematic for subsidized housing tenants who are disproportionately women, disproportionately people of color, and disproportionately seniors. Conditioning access to one's home on technology that does not consistently recognize you or household members just doesn't make sense. And this is the complaint of tenants at Knickerbocker Village, a complex in New York that's been using FRT for building access for a little over 10 years. The tenants in this apartment complex are mostly of Chinese descent, and they complain about the technology not recognizing them consistently, having to stand outside in the rain and the cold because they can't get in, having to wait for a neighbor to exit to let them in or a security guard to come by. So people are being denied access to their housing if the technology doesn't recognize them. But even if the technology could be improved in the future to recognize people better across, gender and age and race, more serious privacy concerns would still persist. And that's what I want to focus the rest of my time on. How the use of FRT and surveillance invades the privacy of people who have no real alternative but to submit to this surveillance and screening. And these privacy concerns were raised by the residents at Atlantic Plaza Towers, an apartment complex also in New York, over 700 units, mostly Black female tenants. And the privacy concerns that they raised in their complaint to the State Office of Rent Administration when their landlord proposed to implement this technology, and what advocates and tenants around the country have identified, those privacy concerns are threefold. First, use of FRT and surveillance in this context conditions people's entry into their home on surrendering biological data to third parties. So the landlord contracts with the AI company who administers the technology and then stores that biometric data. But we are all, reading week after week about the increase in cyber attacks. So this use for subsidized tenants increases the odds of their biometric data being released in one of these data security breaches. The second privacy concern that tenants have identified is that this creates a record of their movements and their associations in and around the apartment complex. Some low-income tenants of color describe this as being like having an ankle monitor, but I argue it's actually more invasive than that because it not just tracks location, it also sends images of people who are not accused of any crime, not convicted of any crime. Landlords know when people arrive in the building, when they leave, with whom the tenants speak, where they go. And this can have a chilling effect on participation in things like tenant association meetings, things like that. And this is one of the issues that the tenants at Atlantic Plaza Towers raised in their complaint. The landlord was pulling out screenshots of the tenants and sending it to them, basically trying to intimidate them to stop their tenant organizing. The third privacy issue that comes up in this context is the interference with personal relationships, because the systems surveil not just the tenants themselves, but also their guests and their family members. And it can incentivize people not to come and visit if they're afraid that, one, they might be misidentified as someone who has a warrant out for them if there's a false positive, or if they don't want to risk their biometric data being released in a cyber attack. So it makes it harder for vulnerable tenants like seniors or people with disabilities to get help from their social networks, especially if the surveillance is being done in conjunction with law enforcement. So to wrap up, low-income tenants have few options for affordable housing. If they forego rent-controlled units or subsidized housing, they're stuck on the private rental market where they face the risk of eviction if they can't consistently pay rent. So the use of FRT and surveillance in this context forces people to give up their biometric data and their privacy just to have safe, affordable housing. I'm happy to answer questions afterwards, but thank you for your time.
Thank you so much, Professor. We're going to now hear from our last presenter on our first panel, Ms. Kinsey. You can proceed, please.
Thank you to the Commission and the staff for calling this important public briefing on law enforcement use of facial recognition technology, our federal use. My remarks will focus on the law enforcement context. My organization, the Policing Project at New York University School of Law, works to promote public safety through transparency, equity, and democratic accountability. By democratic accountability, we mean that there need to be democratically approved rules, laws, and policies in place before policing agencies act. Policing, especially when it comes to the use of emerging technologies like facial recognition, suffers from a lack of this kind of front-end accountability today. This is both undemocratic and it has caused harm to American civil rights. At the Policing Project, we pursue our mission of democratic accountability with all stakeholders. We work with impacted communities, civil rights and civil liberties advocates, tech companies, and law enforcement themselves. We've been researching and studying law enforcement use of facial recognition for a number of years now, and from that research, I have two main takeaways for the Commission today. The first is that law enforcement use of this technology is non-transparent and unregulated, and this is causing harm to American civil rights. The second is that if law enforcement is going to continue to use this technology, it has to be regulated. That is the bottom line. At the Policing Project, we start our evaluation of any policing technology with the same basic question: will the public benefit from use of this tool? Because as any good economist will tell you, when it comes to cost-benefit analysis, you don't even need to evaluate costs until you've established measurable benefits. The problem with federal law enforcement use of facial recognition today is that we lack adequate proof of public safety benefit. Now, how can I say this when you've already heard stories today about facial recognition technology being used to solve serious crime or even exonerate the wrongly accused? What I mean is all the public has today are sporadic anecdotes of success or cherry-picked data, often from the technology companies themselves who make these products. And I can just as readily point to anecdotes of real harm from this use by law enforcement. That includes false arrests. Most recently, a black woman in Detroit was falsely arrested while she was 8 months pregnant, causing her to go into early labor from a facial recognition misidentification. So right now, we have no idea if the successful anecdotes of law enforcement use represent the tip of an iceberg or are exceptions to otherwise harmful uses. And OMB has made clear that federal agencies should not be allowed to use technologies like facial recognition if they cannot prove measurable benefits that meaningfully outweigh the risks of use. The problem is that we need this measurable representative data about public safety benefit of law enforcement use of this technology, and we don't have it today. We don't have it because so far law enforcement use has been very not transparent. And what I mean by that is we don't have answers to basic questions about federal agency use of facial recognition technology. Questions like, how often are federal law enforcement agencies running facial recognition searches? On what types of crimes? On what demographics? And to what result? Are these searches actually leading to more crimes being solved? These are essential questions that we need the answers to if we want to make good policy, but we don't have them right now. Consider the FBI as just one example. They've been running facial recognition technology since 2011. They have their own database that has over 40 million photos of American citizens in it. They've conducted 200,000 searches of this database. We don't know for what crimes. And they spent tens of millions of taxpayer dollars on this facial recognition technology. Now, the Government Accountability Office has also taught us some things about the FBI use so far, and it's that the FBI has only limited information on the accuracy of its facial recognition system. It has no policy in place to protect from the civil rights and civil liberties implications of use. Only 5% of staff who have access to this system have received any sort of training, and they have no mechanism to track FBI employees' use of external facial recognition systems. So despite the FBI's rampant use of this technology, we have very little information about this use, and we lack meaningful oversight over this use. Now, not only is the public in the dark about how federal agencies are using this technology, we also don't know how well or poorly it works, and that's because it hasn't been tested under real-world conditions. What I mean by that is you might have heard folks today already talk about testing conducted by the National Institute of Standards and Technology. This testing is extremely valuable, but it's also extremely limited. NIST only tests algorithms. It doesn't test complete facial recognition systems under real-world conditions on things like the photos that law enforcement is actually searching with the human operators who are actually conducting the review. So to understand the difference between NIST testing and what real-world testing would look like, think about another human-machine system, a Formula One race car. NIST testing is the equivalent of testing just a Formula One car's engine in isolation. Engine testing is absolutely necessary, but it's not sufficient. If you own one of these expensive machines, you're going to test that engine in the car with a driver on an actual racetrack. In other words, you're going to test it in real-world conditions. That's the only way you're going to know how it performs. We don't have that kind of testing when it comes to facial recognition technology, and that means we don't know how well or poorly it works in the real world. So without knowing how law enforcement agencies are using this technology, without knowing to what effect, and without knowing how accurate it is, we have no way to assess the measurable public safety benefits of use. But we do know it's causing real harms. That's the false arrest that I talked about earlier. Others will go into those in much more depth later. But I also want to point out that it causes another type of harm, which is that it erodes community trust in law enforcement, which Chief Aguilar already noted is essential to public safety. So this status quo is untenable. What we need instead is sound governance over law enforcement use of facial recognition. Luckily, we already have really good models for what sound governance requires here. At the Policing Project, we've developed our own federal legislative checklist. OMB's guidance, recently issued on AI use by federal agencies, has absolutely essential safeguards that apply to facial recognition use. The National Academies has a great recent report on governance. Representative Ted Lieu's bill provides a comprehensive framework for law enforcement use. And they all say many of the same things. We need federal regulation. We need meaningful transparency over use. We need real-world testing. And we need national standards and best practices rather than the Wild West that we have out there right now. At the Policing Project, we believe there is real promise for public safety technologies to promote public safety. But decisions to use any policing technology must be democratically accountable, and they must show measurable proof of benefit. They also require real commitment to protecting civil liberties, civil rights, and racial justice. Protecting public safety and protecting civil liberties are not mutually exclusive aims. Law enforcement agencies need to recognize this, and federal policymakers need to make sure that they do. Thank you.
Thank you so much, Ms. Kinsey. At this point, I'm going to open it up to questions from commissioners. So please let me know if you would like to be recognized.
I've got a question.
Okay, Commissioner Jones, go ahead.
Thank you, Madam Chair. I have a question for Dr. Goodwin. In your written testimony, you note something that is alarming to me, which is that at least prior to December 2023, DOJ had no policy on the use of facial recognition technology that at least was intended to implement safeguards for civil rights and civil liberties. But then in December of 2023, just a few months ago, and possibly as a result of your inquiries, they implemented an interim policy, but you had not yet had an opportunity to, quote, to obtain and review the policy and thus could not confirm the information that they represented. Is that because they didn't produce that policy to you? Or and clearly it's not a public policy for us to review.
Yeah, so thank you for that question, Commissioner Jones. So whenever GAO issues a report and we have recommendations, we do recommendation follow-up. And as I mentioned, DOJ concurred with all of our recs. And when we were doing the follow-up, that's when we were told that they have this interim policy. We have asked for that policy. We haven't seen it. We will continue to follow up because with the recs, we have to report back, of course, to the Congress on where each agency that we've made recommendations to, where they are in terms of addressing our recs. So it's something we will continue to follow up on.
Is it normal for an agency to represent to you that they have a policy that they're unwilling to produce to you for your review?
I wouldn't use the term normal, but there is always a back and forth. When we reach out to follow up on where the recs are, we will continue to ask for that policy, and we will continue to report back to the Congress as to whether or not we actually haven't received anything. And then at some point, I would imagine the Congress will be asking DOJ to take a look at the policy.
Yeah.
But again, we do rec follow-up, and that's just a part of our rec follow-up. The minute we have the policy, we will look at the policy, do our own analysis to see if it actually meets the spirit of our recommendation.
Is DOJ under a statutory obligation to produce that document to you, or does that have to be requested by some other agent?
Well, they have a statutory responsibility to respond to our recommendations. And so that's just part of the follow-up that we do with them. And whenever we get any information for any agency that we've made a recommendation to, we will note that information on our website, our public-facing website. So for any report that GAO ever, puts out, and we have recommendations, you can go to the GAO website, you can go to that report, and there's a tab that says recommendations. And every single rec and every single piece of information in terms of follow-up, whether the rec is closed, whether it's open, whether it's partially addressed, we will have all that information there.
So I'm gonna let other folks ask questions, but I want to be clear that you are unable to do your job completely in terms of ensuring compliance because DOJ has not produced this interim policy to you.
They have not yet produced the interim policy to us. That is correct.
Thank you.
Madam Chair.
Can go ahead.
Someone else?
Or
No.
Commissioner Harriet
Okay,
just
please,
asked first,
go
and
ahead.
then we'll go to you.
Absolutely.
My question is for Mr. Tomthat. One of the striking things about this technology is while it's imperfect, human identification is even more imperfect, many more errors. You gave the example of how sometimes this technology has worked to the advantage of the defense in a criminal case, but it was kind of an odd situation. It's a witness. Is this technology capable of finding that a human ID is simply error? So a human being testifies the defendant did it. Has this technology ever been used to say the witness is wrong? Our machine says it's not the same person.
Thanks, Commissioner, for the question. Currently, the status quo for law enforcement, when they can't identify someone before I mentioned, is BOLOs, be on the lookout, getting tips in. And also, another big issue with law enforcement today is eyewitness testimony. So I believe the Innocence Project said that 70% of wrongful convictions that were later then overturned because of DNA evidence came from eyewitness testimony, which is admissible in court. The way our technology works is it just generates leads. We don't allow our facial recognition match score to be even shown to the end user. So in the case you're thinking of, I'm sure when law enforcement is able to use accurate facial recognition like Clearview and then get other evidence, for example, say there's a surveillance footage of someone robbing a store. Instead of relying on the eyewitness to say that's the person, they can be able to say, run the facial recognition search, find another piece of evidence, maybe a matching tattoo or matching clothing, and use that as much more objective evidence than eyewitness testimony. So I truly believe that accurate facial recognition technology can really decrease the reliance on eyewitness testimony, which has been shown to be unreliable. At the end of the day, for defendants and for prosecutors, everyone wants to get to the truth of and evidence. So this allows a more objective way of policing. Thank you.
I'm going to jump in here and just ask a follow-up question to that. Aren't individuals also looking at this data? So it could complicate this problem that you're saying is solved by eyewitness testimony? I mean, we hear from police agencies that they're also reviewing the information and looking at the matches. I mean, you know, how do you explain that if we've got a lot of people actually looking at this data?
Yeah,
too?
so I'm a true believer that there should be a human judgment at the end of the day. I don't believe in automated decision making at all. So the way we've designed our technology is we give training to every user before they use the technology. We make sure that the agency has approval to even run a trial of Clearview AI. We recommend that agencies have a public facial recognition policy as well. And as part of the training, we show that this is just lead information. So I think for investigators, the more information that confirms who someone is, but also disconfirms who someone is, can be very valuable. So yes, these investigators, the more data is more likely to actually confirm the person, or maybe it actually is someone else. So in the example of what the status quo is today is basically if you can't identify someone, you send out a BOLO, be on the lookout. It has the person's like race, their gender, rough age description, maybe they have tattoos or not, and that means law enforcement is like pulling over people that are innocent to try and ask questions. With accurate facial recognition, you can skip all that stuff if you vet it properly and get the right identification. So I do believe that it does improve civil rights and civil liberties overall.
Is the training that you have, and then we'll go to you, I'm so sorry.
No, you're fine. You're asking the same questions I want to ask.
If it's mandatory, was that your question?
Well, no, I'm sorry, Madam
Well,
Chair.
I'll ask my question. So is the training mandatory, and is it uniform across all police agencies that you work with?
Yes.
What does it look like?
Since early 2020, we have a mandatory training for all users. So we train an administrator. So everyone who uses Clearview has a designated administrator who can oversee all the searches for that agency. So that allows the administrator to make sure that they're using it for a proper purpose related to law enforcement. Then we train each of the end users, and as a requirement of Clearview, before you conduct any search on the platform, you have to put in a case number and a crime type, essentially a reason for doing the search. And so, yeah, that's what we do. That is separate from, say, some of these federal agencies who also have their own training programs. Even if an agency has its own training program, we still provide ours as well.
And the end user would be the police agency using?
Correct. So from the administrators down and the end users who are doing the investigation.
And the administrator would be someone in the agency as
Correct.
well?
Yeah.
Okay. I'll let you ask your question, Commissioner.
Thank you, Madam Chair. Before I ask my question to Mr. Tad, I will come back to you. I certainly want to thank my colleague, Commissioner Jones, for his leadership on this initiative. I think he allowed me to offer some input into this discussion today, and I certainly appreciate the opportunity to do that. So, Commissioner, thank you. My question about training is a little bit different. It's more so geared toward training the models to deal with AI. Can you talk a little bit about that part of it? Because I think, and I'll ask this question particularly with regard to regulation, because I think this gets into the algorithmic side of this that I would like to really understand a little bit better. So,
sure. Thanks, Commissioner Gilchrist. So earlier, algorithms regarding facial recognition wouldn't use AI or machine learning, and were quite inaccurate. So they would do things like measure the distance between the eyes, or look at skin color, really kind of basic things. But with the advent of machine learning and artificial intelligence, facial recognition has got remarkably more accurate. And the way it works when you train an algorithm is you try and find photos of many different people in different demographics, in different poses. And the more data that a model has, the more accurate it gets across different demographics. So over time, what we've been able to do is pull millions of photos from the public internet to train our algorithm to be more accurate.
So if something is disproportionate, does that in some way could potentially disproportionately train the algorithm?
That's a great question. It's not quite related to the proportions. What we found is the more examples there are of any demographic or any type of person, the more accurate it gets across all those demographics. So if you look at Clearview's accuracy across in the NIST 1 to N test, with the highest threshold NIST has, white males are at 99.99%, black males are at 99.97%, white females are at 99.98%, and black females at 99.93%. So this wouldn't be possible without the advent of machine learning. You can gather a lot of data to make these models more accurate. I think the bias that an algorithm has today with the top performing algorithms is, kind of negligible. The flip side is, people always say, even if the algorithm is accurate, does it make policing more biased or less biased? And I think that comes down to the data set you search against. So some other vendors for facial recognition only search against mugshot data.
Right.
Right. So what's that going to do? That's going to affect people who've been through the prison system before. Our system searches through data from everyone from the public internet. So I really do believe that is a way to decrease bias in policing, on a systemic level.
And so from a regulatory perspective, do you think we should focus more, do you think we should think about regulations with regard to regulating the algorithmic side of it, or do you think it should be on the end-user side?
I think it's both. We are a proponent of facial recognition regulation. Mm-hmm. We've took it upon ourselves to not sell this data set beyond government and law enforcement. Some states like Virginia have passed laws where you can use facial recognition for law enforcement, but there's a requirement that there's a minimum accuracy level according to NIST. So I think, we're very open to regulation, and we think it's a good thing. It will build trust with the community, with policing, and with the general public.
Thank you.
Commissioner.
I'm going to jump in here. I see that Mr. Lee, you want to be recognized, and then I have a note that Commissioner McIntyre has a question on the phone, so we don't want to forget our commissioners that are on the phone. Go ahead.
Thank you.
Go ahead, Mr. Lee.
Sorry, I just want to clarify a few things that Mr. Tomdat said about kind of the AI behind Clearview AI and what is really implicated when you're using publicly scraped information on the internet from social media platforms. One of the things that we have to keep in mind is that not everyone has access to the internet. Not everyone shares photos on the internet. And there's still many parts of the United States that don't have consistent internet access. There are many different kinds of people who don't have social media. The early adopters of these technologies are disproportionately white. And so when we're talking about publicly scraped data and publicly scraped images, disproportionately it's going to lean for the fundamental training set and the fundamental training data of these facial recognition systems are fundamentally going to lean disproportionately towards being more accurate for white users than they are for people of color. And one thing to kind of highlight for Mr. Tomdat's point about the 1 to N point from NIST and the training set. So 1 to N is 1 to many. There are different kinds of facial recognition tech searches. One you could do is like when you're going into TSA, for example, they check your face versus the face on your passport. That's 1 to 1. 1 to many is searching your face versus millions of images or thousands of images to see if you are the person or see if there's a match in there. And I think that's important to contemplate because one of the things that happens is at scale is where the issues lie. So even if you do have 99.9% accuracy, right? I don't know, Mr. Tone, that you would be able to say that your accuracy is the same for black people as it is for white people. And that differentiation across scale, hundreds of thousands of images that are being searched, that Mrs. Goodwin highlighted that law enforcement is engaging in, based on those hundreds of thousands of images, there may be in those hundreds of thousands of images, hundreds, if not thousands of people who may be wrongfully identified within those data sets. And I think that's an important distinction to make here because we're not just talking about one individual, we're talking about hundreds of thousands, if not even millions of individuals. And unfortunately, the commission doesn't have the information in front of it to be able to say how often law enforcement is using it across the nation in local law enforcement, and then also how often the federal government is using this within the context of law enforcement as well. And so that's just something to keep in mind as we have this conversation.
Go ahead, Mr.
I just wanted
Tunda.
to clarify a few things. So the NIST 1-to-1 test, that's measures, that's the test that also measures the demographic breakdown across different demographics on accuracy. But the 1 to N test, which is can you pick a photo out of 12 million images, Clearview is still 99.85% accurate for that. So can you imagine trying to go through 12 million images and try and pick out the right person? It's got a very high level of accuracy. I do agree with Mr. Lee that getting more information about how law enforcement is using it is really important, because that's how everyone here can learn, the positives and the negatives about it. So we provide in our technology a way for the administrators to oversee not just the searches that have been done, but general information. How many searches per month? What type of crimes were they used against? Were these cases closed or not? So as a vendor in the space, we're very committed to helping law enforcement get that information and so they can report to the public or to GAO and other places about it.
Yeah, we're still waiting for some information. I'm going to go to Commissioner McIntyre first, and then I'll go to Commissioner Adams, if that's okay. Okay.
Thank you, Madam Chair. Glenn Mafante. Thank you, Mr. Tantat and Mr. Lee, for your comments. Really quite illuminating. And Mr. Tantat, I really do appreciate your presence here and your testimony. You just rattled off a couple of percentages for white women, white men, black women. Do you have other demographic groups? And if you don't have it right now, if you can provide that to the Commission, I would like to see that as well. Thank you.
Thanks, Commissioner McIntyre. The NIST report, those numbers are drawn from there, and they do have other demographic groups and ways to measure things beyond those, like country of origin and so on. So I'd refer to the NIST report. It's very thorough, and I'm a resource as well if you want to follow up with me on anything else specific. Thank you.
All right, thanks.
Commissioner Adams.
Thank you, Madam Chair. Professor Ewert, and I apologize, it's German.
You got it.
Okay. I was very sympathetic to your comment that there's surrendering biological data to third parties, is what you said about these residents. And I'm sympathetic to that concern. Isn't the horse a little bit out of the barn on this? I mean, do the residents there have, for example, phones with Google and location tracking and heartbeat tracking and all the other surrendering of information, biological information to third parties that's already taking place? And how do you square the two? You're extraordinarily concerned about in facial recognition. What do they say about in all the other biological data they're surrendering?
So this is the crux of the issue. Can people give meaningful consent to the use of FRT and surveillance? And so, someone can choose whether to use a smartphone and how to use a smartphone, can choose whether to participate in the Trusted Traveler, program for, airport access, things like that. The issue with people like my clients, low-income Americans who are in subsidized housing, that I would argue there isn't really an alternative. For example, if you are someone with disabilities and you subsist on SSI benefits as your only source of income, you get $943 a month. And I don't think there's anywhere in the U.S. where on $943 a month you can pay market rent and your utilities and your household products. I'm leaving food out of that because hopefully folks are applying for SNAP benefits, transportation, the other things, and have a cushion left over. So if there is an economic, emergency that you face, you can pay for that as well as your rent. And so for folks on very fixed incomes, if you are not in subsidized housing like public housing or Section 8, where your rent goes down when your income goes down, you're at very real risk for eviction. And what are options for folks if they get evicted from, the market rate housing or even subsidized housing? They might, if they're lucky, would be able to couch surf with family and friends. But that's not reliable, and that also puts their family and friends at risk of eviction if they're renters. They're not supposed to have unauthorized occupants. Second option, if they have a car, they could live in their car. Not convenient, not easy, not particularly safe. A lot of low-income folks don't have cars. What's the third option? Going to a congregate shelter. There are a whole host of problems around that, and God forbid you're a woman who has a teenage son, because a lot of congregate shelters don't allow boys age 14 and over to stay with their families. And so where does that leave you? Outside in an encampment, which is not safe. And so if you're a person on a very fixed income, subsidized housing is your best bet for staying safely housed. And so I would argue that the consumers who are using this housing, who are submitting to this surveillance and this technology, don't really have a good alternative. And a lot of the regulatory proposals are focusing on consumer consent. Can people opt out? Do they understand what they're agreeing to? And that simply is not an option for my clients who depend on subsidized housing. I hope that answers your question.
Commissioner Jones?
Thank you all for your testimony. This has been really instructive. I am sympathetic to Ms. Kinsey's argument that we've got a real challenge because thus far we have overwhelmingly relied on the representations made by departments, agencies, companies, like Clearview even, in terms of anecdotal data and whatever statistics that may be trotted out, without an ability as the public to independently corroborate sort of representative data. Obviously, we can all do the anecdotes, and these are compelling anecdotes, by the way. So thank you. So with that, I wanted to ask you, as a CEO of your company, has Clearview conducted or facilitated and then publicly released the results of any operational testing of its FRT service as used by law enforcement agencies?
Thanks, Commissioner Jones. As a vendor, as a company, we are always encouraging our law enforcement partners to share their positive success stories and also track on a statistical way the results of the facial recognition. We're providing tools right now where it's very easy for any user of Clearview as an administrator to go in and generate a report on how many searches, what type of crimes have been solved with it, and so on, who's doing the searches. But I think there's more we can do as a vendor. But at the end of the day, it comes down to those law enforcement agencies and their willingness to share. And unfortunately, it's not that many of them who want to be as transparent about how they use it. And I think some of the reasons are, and I can't speak for them, is they're not always comfortable revealing their investigative techniques. However, I do think that's an area that we are looking to do more of. We haven't made any plans for it yet, but we've thought of ideas where we can start collecting more information and help law enforcement track the actual outcomes at the end of the day. For example, number of dollars saved, number of arrests made, number of identifications. And we want to help them do that by putting that into our software. And hopefully, if enough of these agencies who are our clients end up doing it, we could probably generate a more comprehensive report that covers things across all these agencies. But I think a lot of it comes down to the unwillingness for various reasons of law enforcement to get into more detail.
So I want to be clear for everyone listening that was a no in response to my question. And so, but you guys are touting an oversight function. I mean, so technically you do have the data. It's just that it's up to the agencies with respect to whether they want to release that data. And is that, are you contractually prohibited from releasing sort of data that is not specific to the agency, but just sort of?
Yeah, I would say that we store and house their data, and we don't have direct access to it. It would be a violation of their expectation around sensitive criminal investigative data to share that without their consent.
Yeah. Okay. I just wanted to ask the question.
Yeah. Thank you.
Yeah. No problem.
Chief Aguilar, and then I know we have a question over the phone from Commissioner Kirsnell, but I'll go ahead and let you, Chief Aguilar, speak.
Just thank you, Chair. Just a quick follow-up to your question, Commissioner. So I don't have the exact data. When I looked at it, I believe it was based off of our 2002 data, but we're looking at, because we are one of those agencies that has been very transparent, everything from our policies to our use of the technology in criminal cases. At last check, we were at about a 40% rate of positive identifications. Now, that doesn't mean that we had a 60% false match rate, right? With that, because there are a lot of variables involved here. Number one, it relies on the detective or the officer that requested the search to our real-time crime center to report back, which we wish always happened, doesn't always happen, but to report back and say, yes, that match that you sent me was in fact positively identified as a suspect, as a victim, as a witness in this case. But again, we're looking at variables such as we have a probe photograph, it gets run through the system, and there's no return because there's no photo on the other end of the database. But our positive ID rate is roughly 40%.
So, as I understand your testimony just now, you're running a search, there's a hit, and at least based on what you just said, only 40% of the time does that turn out to be an accurate hit?
No, because again, many variables, right? So now, most important thing, right? That and in our search results that get sent to our detectives or the officer that's requesting that search. Most important part of our policy is printed in bold letters in the top of that hit, which is this is to be treated only as an investigative lead, not as probable cause. So now that detective has to go out and do their due diligence. For example, putting a photograph of that suspect into a photographic lineup. Well, now they go to an eyewitness, and the eyewitness can't identify, right? Doesn't have an accurate enough recollection. We can't find anybody to accurately identify that potential suspect. The case could go cold after there if there are no other leads.
Yeah, no, I understand that perfectly. I mean, which speaks to the importance of having an actual human being and a policy that says this match is not going to be treated as probable cause, for example. But it is alarming that before human intervention at the end of that hit turns out to be accurate to the extent of 40%. I mean, that speaks to, I think, the fallibility of the software.
Well, if I could, I think that we may agree on this more than it might seem, right? I think that actually speaks to the strength of our practices, right? That we're not running out and making an arrest just because an algorithm tells us to do so. The robots haven't fully taken over yet, so the humans are still in charge. I think that it just, again, speaks to the due diligence that's happening on the human side of that investigation and saying, great, we have this match. Let's gather as much evidence from other sources, right, physical testimony or circumstantial evidence as we can to either make this case or not. And so I'm quite happy that 60% of our searches do not result in arrests. I think that's more a testament to the fact that we're not using the technology indiscriminately.
And which software are you using, by the way?
We use Clearview AI, and we use a program that's run out of one of the counties in Florida, the Pinellas County Sheriff's Office, that shares their database with all Florida law enforcement agencies. The program is called Faces NXT.
Do you have a comment?
Yeah, I just wanted to follow up on Commissioner Jones's question because I think it makes the colloquy there is kind of the baseline point I was trying to make today, which is that without regulation, we're not going to get the kind of transparency and information that we need. So I think the response to your question about operational testing that Clearview does was basically, well, that's up to the agency. So you're going to continue to get this kind of buck passing if there isn't regulation that requires it and sets these responsibilities out there. And we can't rely on a responsible agency like Miami PD to set its own rules that might need to be the rules for all agencies to follow, and that we can't just ask permission for these things. We need to regulate these technologies.
Yeah. Well, I appreciate that comment, and am in agreement that at the heart of this is really about finding some kind of policy to ground us and making sure that we're protecting people's civil rights and civil liberties, and to things such as basic as their freedom and their housing. I know we have one question on the phone. That'll be our last question for this panel. Unfortunately, I know we can be here all day. Commissioner Kirsnow?
Thank you, Madam Chair, and thank you to the witnesses. This is for anybody, but I'd like to direct it first toward Chief Aguilar. Do you maintain data related to the percentage of false positives by eyewitnesses versus the percentage of false positives related to facial recognition technology?
So, no, we do not maintain data anytime where, if I understand the question correctly, where there's been a face recognition match and the case has, I guess through other means, identified another suspect. Was that the question?
Right. And how does that compare between facial recognition technology versus eyewitness testimony or eyewitness recognition?
So again, we don't we don't keep data specifically on either one of those two. But what we do know from the research and much of the testimony that we've heard is that eyewitness testimony is in itself fraught with problems. And so, but no, we don't track how many times somebody doesn't identify somebody. And again, there are many variables there, right? But the short answer is no, we don't collect data on either.
Thanks, Chief. And my follow-up is to anyone who has data or an answer, and that is, are the percentage of false positives related to race comparable or wildly disparate from percentages of false positives related to any other protected class, such as sex, age, national origin?
Yeah, thanks, Commissioner. If you look at another thing that's really important for facial recognition is image quality. So NIST also tests visa photos versus mugshot photos versus what they call border photos, which are photos at the border from different angles. And they also test what they call wild photos, which are photos from all different types of angles. If you look at the differences between accuracy, for example, between wild photos and mugshot photos, that's much, much greater than, say, accuracy between black men and white women. So yeah, there's other parts of the NIST report that are quite thorough that go into the types of photos that are being tested against.
Mr. Lee?
I think that's a slight misinterpretation of the data. I would disagree with that finding. I would argue that even if you have a 99% accuracy, right, it's 1 in 100 people are likely to be misidentified. And it's just the likelihood of that one person being of color or not. And to answer your question, Commissioner, if you look across the NIST one-to-one variables, consistently you will see the biggest difference in false match rate is between either East Asian people and black people or white people and black people, particularly amongst black women ages 65 to 99.
Can I respond to the eyewitness question?
Sure.
So I feel like this has already been brought up a couple times today, and I think it's a bit of a kind of false premise that facial recognition and eyewitness ID are opposite sides of the same coin, because facial recognition is a process that involves human reviewers at multiple points in the process. You have an officer reviewing the results, and then you often have an officer taking those results and having another eyewitness review those results. So you're not separating out the issues of eyewitness ID from facial recognition technology. There's actually the possibility that they could compound and amplify the issues that you see with eyewitness ID. And there's been studies that show that facial recognition technology, because it does a good job of pulling out similar looking lookalikes, so not the actual person, but the most similar looking people, it makes the task of the human reviewer reviewing those results more difficult, because we're not good at distinguishing among unfamiliar faces. So I think we do definitely have a need for data on this. You know, what are the rates of eyewitness ID and accuracy? What does it look like when you combine that with facial recognition? But considering them as two separate pieces, I think is not accurate when you think about how facial recognition actually works.
Thank you for that. That was kind of going to the point I was making earlier about how you still have people interacting with the system, with the technology itself. So we're going to have to leave it there. We are at time. Thank you all, each of you, so much for your testimony. We appreciate you making the time to be here, and we're going to take a brief break and reconvene at 11:35 with our second panel. So.